All right, we're back. This one's going to be shorter, I think. Slide-wise, it's shorter, but I also do really enjoy talking about this. So we're going to talk about protected speech. So what can you say, or what can you express and have the government say, yep, that's fine. You're allowed to do that. All right, so we have symbolic speech is protected speech, and what's called content or viewpoint neutral laws. So like if I owned a business and I had somebody so our Senate race this year in Michigan is Gary Peters, who's a Democrat. He's the incumbent, versus John James, who's a Republican. And if I owned a business and Gary Peters people came to me and said, I would like to post a sign on your property. And I said, nope, I'm not going to have that. And then John James came and said, I want to post a sign on your property. I said, yep, that's fine. That's a problem. So if you, as a business owner or, a government entity, if you have a rule that you don't post any signs on your property, that's great. If you can't post specific signs, then that's not. Now, of course, personally is totally different. Like just because I put up a Gary Peters sign on my lawn doesn't mean I have to put up a John James sign. Although if any of you drove by my house at any point before the city council election, it was ridiculous. I had all 4 lawn signs for 3 candidates on my lawn, but like I know all of them, so we just can't say no. All right, so anyway, content or viewpoint neutral laws. So it has to be essentially like looking at things the same way, regardless of the viewpoint of the person or the law. And remember that Masterpiece Cake Shop case. What they found was that the state of Colorado was not. They were not like upholding their civil rights law in a content neutral way or a viewpoint neutral way. Like they were asserting that, freedom of, or your personal freedom from being discriminated against outweighs somebody else's religious freedom. So they said that the civil rights law that was put in place was not viewpoint neutral on its face. And so that was the issue with the Masterpiece Cake Shop ruling. So anyway, that's a content neutral or viewpoint neutral law. Okay, so required case alert. Tinker versus Des Moines. I know for sure you talked about this in civics because the one time I taught civics, we did talk about it. It's probably the most famous school case that there is, and this, of course, happened in 1969. So Tinker versus Des Moines is it was a pair of siblings, Mary Beth Tinker being one of them. I don't remember her brother's name. And then they had a friend or two who decided that they were going to protest the Vietnam War by putting black armbands around on the outside of their shirt, at school. And there was a bunch of other things they were going to do to protest as well. But school officials got word of the fact that they're going to do this. And like before they could do it, created a policy that stated that any student wearing an armband would be asked to remove it, with refusal to do so resulting in suspension. So like, I think probably one of the school's main issues there was that they really wrote that rule a little bit too narrow for the purpose. If they would have written a uniform rule instead, they probably would have won this case, but they did not. So the students wore their armbands and, of course, were suspended under the new policy. And both the district court and the Court of Appeals dismissed the case without even ruling on it. But the Supreme Court took it anyway because they thought that it was a big enough deal that they should. So the constitutional question here was the policy that said that the kids could not wear the armbands in public school as a form of symbolic protest, was that a violation of the students' freedom of speech or freedom of expression guaranteed by the First Amendment? So by saying to the kids, you cannot stand up for what you believe in by wearing just a simple armband. It's not like they're wearing shirts that said like F Vietnam, you know what I mean? So it was like, it's a totally different, whatever. Anyway, it doesn't matter. So the ruling was 7-2 for Tinker, so for the students. And really what you have to take out of this case is that you don't lose your First Amendment rights immediately when you step on school property. Now, that being said, there are ways in which, or times in which, it is okay for administration or school officials to suppress speech, but they would have to be able to prove, according to the court, that the conduct in question would, quote, materially and substantially interfere with the operation of school. So, like, do the armbands, like, do a few kids wearing armbands, does that materially or substantially interfere with the operation of school? No. If Mary Beth Tinker and brother and friend said, okay, at 10 o'clock, we're all going to get up, we're going to leave our classrooms, we're going to walk through the halls chanting, no more war, no more war. Okay, now we are materially and substantially interfering with the operation of school. But symbolic protest, not actual protest, but symbolic protest, and so then symbolic speech is protected. So you do have some First Amendment rights at school. That's what came out of that case. Another symbolic speech. God, I hate this case. Like, I hate it. I hate it so much. I can't even stand it. So Snyder versus Phelps. But again, like I said last time, you have to, if you're going to say that one form of speech is protected, you have to say that all forms of speech are protected, whether you like what is being said or not. So this is about the Westboro Baptist Church, and they are very well known for having very stringent, I don't even want to call them conservative because I think that's an insult to conservatives, very stringent beliefs on how people should live their lives. Okay. So the members of Westboro Baptist Church decided they picketed funerals, and they happened to picket a funeral of a deceased Marine, Snyder in this case. And what they were doing, they were protesting gays in the military. Snyder, by the way, was not gay, okay? But they just decided, they decided several different funerals to go to do hold these protests. And so they were holding signs that said, "Thank God for dead soldiers," and "fag troops." And I would never, ever in a million years say that word, except I'm just telling you what was on the sign. But the family of Snyder sued. And in district court, they were awarded $5 million from Westboro Baptist Church. And then in the appeals court, that was reversed. And when it got to the Supreme Court, they held the reversal, meaning that they found 8-1. So 8-1, this is in 2011, 8-1. So even the liberal justices were ruling for this for Westboro Baptist Church. And, as much as it killed them to do that, and I do not think that this was an easy ruling for, any of the justices. I mean, Antonin Scalia was probably the most conservative on the court at that time. And I mean, he even had huge issues with this too. But again, you have to, if you sit in that chair, you have to interpret the law. And the law states that freedom of expression is permitted in most cases. And this was a case. They weren't inciting a riot. There was no violence that happened after this. So the court said, sorry, like, free speech includes protests like this. I mean, if they're going to include, like the Women's March, then they have to include this sort of protest too. So the interesting part of this is sometimes dissenting opinions can create majority opinions further on down the line. So the lone dissent in this was Samuel Alito. And he argued in his dissenting opinion that quote, our profound national commitment to free and open debate is not a license for the vicious verbal assault that occurred in this case. And I'm waiting for this exact dissent to appear in cases as our country becomes more divided ideologically, and as protests become more widespread and with more tendency toward, horrible hate speech and violence. So I'm waiting for this to come up and be used, as justification in a majority ruling at some point. Hazelwood versus Kuhlmeyer, another case you might have talked about in civics. That was out of 1988. If you listen to the free speech part 1 that I did the lecture before, I talked about my school newspaper, The Tower, and how there's like censorship in school newspapers is often upheld a lot more than censorship or prior restraint, whatever you want to call it, in like regular normal publications. So in this case, I'm sorry, it's like when I start talking, I start yawning. The principal pulled 2 articles from the newspaper, school newspaper, prior to publication. And his argument for pulling them and exercising prior restraint was that he thought it was inappropriate for student publication, and that it was on divorce and teen pregnancy. And I mean, at least in divorce, you're like, really? Because, half of all people in divorce that got married now. But this was in 1988. So it was a little bit different time, and it wasn't, my understanding of this case is that it was not advocating teen pregnancy. It was not telling kids to go get pregnant. It was an informative article about teen pregnancy. And I want to say that it held an interview with a girl from their high school who was a teen mother. And so it was kind of a cautionary tale, but the principal just said, nope, we're not even going there. So the students, Kuhlmeyer being one of them, sued the school for violation of their First Amendment. They argued that was censorship, or that was prior restraint. So the question here is, did the principal violate the student First Amendment right to free speech, or in this case to freedom of the press, by exercising prior restraint and pulling the pages? And the answer is no, they did not. So the court ruled 5-3 in favor of the school district. And they said that schools had the right to refuse to sponsor speech that was inconsistent with, quote, the shared values of a civilized social order. Now, again, I mean, you can talk about like, okay, now if you say that like divorce is not like a shared value, I mean, obviously, like nobody wants that, but that's pretty insulting to people who, are of parents who are divorced, but, that's neither here nor there. But the significance here is that prior restraint or censorship is in most cases actually okay in school. And it goes back to this point right here, this refuse to sponsor speech. The school allows the paper to exist. And if the school allows the paper to exist, then the school has ultimate say in what gets published and what doesn't. Now, if you have a principal who needs to read every word of your paper before it gets published, yeah, that's a little bit different, but probably would still be upheld. But that, again, it's you think about it as like school-sponsored events or school-sponsored, in this case, publication. There's a lot less that the school has to think about in terms of rights being violated, I should say. And then another famous one, again, probably I'm sure when you heard in civics, is Texas versus Johnson. This is from 1989. So Gregory Lee Johnson, he was a Texas resident, and he was not a fan of the Reagan administration and his policies, and so he burned an American flag as a means of protest. And the problem with that was that there was a Texas law on the books that outlawed flag desecration. So obviously, like, there are instances in which you are supposed to burn your flag, right? And that's really the way to dispose of flags, but this was not done in that way. This was done absolutely, and like, I'm just gonna like set this flag on fire, and that's my way of saying, a big F you to Reagan and the country and what have you, and like, this is not the America I know and love. Here goes my flag. Okay, so there's a lot different than like, this flag is old and worn and tattered, and the way to get rid of it is to to burn it. So anyway, so he was sentenced to a year in jail and assessed a fine. And then the Court of Appeals reversed the conviction. And then this case went all the way up to the Supreme Court. And the question, of course, excuse me again, my kid, I'm so sorry, is the desecration of American flag by burning it or otherwise a form of speech that is protected under the First Amendment? And the Supreme Court ruled, it was a contentious ruling, it was 5-4, but they did rule in favor of Johnson. And they said, much like the Tinker case with the armbands, that was symbolic speech. And if that is the way that you choose to protest, then that's okay. Now, if your flag burning also then burns down a building, or somehow causes somebody harm, then of course now it is not. But you simply burning a flag in protest is your constitutional right. And again, this is another case that is so controversial. There's a lot of people in our country, arguably almost half, who believe that flag burning should absolutely be illegal. So as the court becomes more conservative, it'll be interesting to see if this case ever kind of comes back around, especially now that the balance of the court is 5-4 for conservatives. So just to see if they would, kind of take this up again, and how a modern court would rule on this. And I say modern, it's not like 89 is that long ago, but certainly I think that the flag has been, taken by the conservative movement. A lot of like the hard right conservatives believe that like the flag is theirs and theirs alone, and that liberals hate the country and hate the flag. And so, when you see a flag now, like an American flag, sadly, it doesn't necessarily look the same as it did before, where you're like, boy, that person just has pride in our country. Isn't that great? And everybody's an American. Everybody's flying the flag. Now the flag is seen by a lot of people almost as like an incitement. And that is the worst part about all of this. Like, the flag needs to go back to belonging to everybody. And I don't know that a lot of people feel that that's the case right this second. Okay. This is my favorite. Can I say it again? Favorite case. You are not reading that incorrectly. That banner says bong hits for Jesus. Okay. So this was an actual banner, and I'm so bummed. There was a place called the Newseum, and I did not mispronounce that. It is Newseum, so museum for news. That was in DC, and the last time I was in DC, we meant to go, and then we we couldn't get tickets to get in, and it has since closed. But it used to display this banner there. Okay, so this is an actual banner that was held at a school event by a bunch of kids, and I'll just go through it. Okay, so this case is Morse versus Frederick. Obviously pretty recent, 2007. So Joe Frederick, who was a student, and then the principal, last name was Morse. So that's Morse and Frederick. So he displayed signage that at a school event. And it wasn't like at a pep assembly in the school. It was outside of school, but it was like a school sponsored event. Okay. So it said bong hits for Jesus. And then Morse, the principal, suspended the student for 10 days and justified his suspension on the fact that your school policy, like we have school policy that is to not promote drug use, right? And who knows what this kid was thinking, right? So, like, clearly that's a bad idea to write anything about bong hits. And I don't know if he thought that since he was writing for Jesus, that he was, would be protected by his First Amendment right to free exercise. But, like, I don't know that you can make that connection that, like, Jesus wants you to take bong hits. So, I'm not really sure where he was going. But anyway, so Frederick sued the school to get his suspension taken away and cited, his First Amendment right to free speech. And the district court ruled in favor of the principal. And then, unbelievably, the circuit court ruled in favor of the student. And what he said was that, so he cited the Tinker ruling. And remember way back that the Tinker ruling said that unless it is like creating conditions in which a school cannot function normally, then you have to allow it. So again, the circuit court said that unfortunately here, we don't like the fact that the kid is like holding up a sign, this is bong hits for Jesus, but you're punishing the message, not the disturbance. So again, according to the circuit court, if this kid held up the bong hits for Jesus sign and then all of the kids brought out their bongs and started smoking pot, then now we have an issue, right? But what the circuit court is saying is like, that's fine. He can say that because like that's his right to say that. So how did the Supreme Court rule? I'll give you a second to think about it. Because again, like the district court ruled in favor of the principal and then the circuit court reversed it. And then the Supreme Court said 5-4. So again, a very slim majority. And I put this up here so you could see the conservative justices ruled in favor of Morse. The liberal justices ruled in favor of Frederick. And that is not because the liberal justices are big old potheads. It's because they believe that the speech should have been protected. So the majority opinion was written by Chief Justice John Roberts, this guy right here, and he said that the right to free speech just simply does not extend in schools to promoting drug use. Okay, fair enough. And then Thomas, so Clarence Thomas, who says very little in court, wrote a concurring opinion. Remember, that means he agreed that the ruling should be for Morse, just from a different angle, though. So Thomas said students have no rights to free speech in schools at all. And by the way, the court should consider overturning the Tinker versus Des Moines case. So, like, you have Roberts who's like, yeah, no, you can't do that. And you have Thomas who's like, bam, done on free speech. And again, though, if you think about free speech and who like traditionally believes in it from a court perspective, conservatives do, right? So it's interesting that the school case kind of goes the opposite way. Anyway, Justice Ginsburg wrote a dissenting opinion in which she said, quote, constitutional imperative. We have a constitutional imperative to promote unfettered debate even among high school students. So Justice Ginsburg thinks that you should be able to hold up a sign that says bong hits for Jesus. And we're not in school anymore, as you know, but every single year I have kids say, so can we try that at like the senior versus staff games? I'm like, nope. And then when they talk about getting AP shirts. They're like, can we write bong hits for Jesus on our shirts? No. Can we just write Morse versus Frederick? Nobody will know. Like, no. So anyway, it is my favorite case because I think it's so like unbelievably crazy that that this case ended up at the Supreme Court. But it's an interesting interpretation of your First Amendment rights at school for sure. All right, unprotected speech. Like I said before, libel, obscenity, fighting words. Libel, like I said, is written. Slander is spoken. So libel is like published, right? And then slander is like you actually say the words. Okay, I don't have too long to go here. So libel, excuse me, not liable, falls under this umbrella of defamation. So if you hear somebody suing for defamation of character, that means that they are, trying to say something about you that is not true, and in that way harm your reputation. The problem with defamation is that in almost all cases, it is very difficult to prove, particularly if you are a public figure. So if you're a public figure, you have to demonstrate actual malice to prove the case. And what actual malice is that you have to prove that the target of the statement, that the person who made the statement made it with knowledge of its falsehood or reckless disregard for its falsity, but falsehood. So like, I know what I'm saying about you is untrue, and I'm gonna do it anyway. But even with that standard, it's still so difficult for a public figure to do that. And the interesting thing too is you think about publications like the National Enquirer, right? And now you have like the Onion, right? So things that are like dedicated to satire. This case, Hustler magazine versus Falwell. So Hustler magazine is a men's magazine on the line of Playboy. There's a movie made about not this particular instance, but Hustler magazine. That was called The People versus Larry Flynt. Woody Harrelson plays Larry Flynt in that. He, I believe, is the publisher of Hustler. It is a very, very good movie on like, First Amendment rights and that kind of thing. It gets a little seedy in there, so I don't show it in class, but the Hustler magazine versus Falwell. So Jerry Falwell was a televangelist, or maybe not a televangelist. He might have been just a very famous preacher. But they put an ad in Hustler magazine that is a fake ad. And when it's Jerry Falwell talks about his first time. And of course, if you are to read this, so this is Campari, I don't know if it's gin or vodka or whatever it is, but it says, you'll never forget your first time. And so it goes through and creates this fake interview with Jerry Falwell, implying that the first time that he had sex was with his mother. And Jerry Falwell, being a very religious man, was very upset by this and sued Hustler magazine and said that this was libel and again, under that umbrella of defamation. And the interesting thing is that the Supreme Court ruled in favor of Hustler magazine and said, sorry, Jerry Falwell, but like, this is clearly outrageous and clearly inaccurate and done from a point of satire. So no, you can't win this case. You cannot sue these people for something that is so unbelievably out there that like literally nobody would believe what you're saying. So the standard for defamation, very high. Nicholas Sandman, if you remember this gentleman, I wrote this last year, and this case ended up settling. It did not settle for $500 million, but the Washington Post, I believe, actually did pay him a decent sum of money. So this was the one. This was the kid who had a very public confrontation. He was on a school trip in his Make America Great Again hat, and he was from Kentucky, I believe. And he had a very public confrontation with a Native American gentleman, and they were like each trying to kind of get to the same place. And the thing is that the way that the video came out in the media the first time, it definitely showed Nicholas Sandmann as the instigator of this issue. And then if you backed it out, you zoomed out, you would see that that wasn't necessarily the case. Like that also the Native American group was, like they weren't innocent in terms of like whose fault it was that like this clash happened. So he ended up like, I mean, this kid's face was all over the media and people were destroying him. And he ended up, like colleges were saying that they would never, admit him. And he was saying that essentially like his character had been completely ruined. And I actually wanted this case to go to court because he's not a public figure. And so he doesn't have like that. You don't have to meet that threshold. But then you can argue, well, now he is a public figure and he is a public figure because of, what happened. So then now does he have to meet that standard? So it would have been a super, super, super interesting case to watch. But again, like I said, the post settled. I don't remember, like I said, for how much. So just moving on, Clarence Thomas has publicly called for a reversal of Sullivan. Sullivan meaning the reversal of Sullivan would mean that would lower the standard of actual malice to sue. And then my question, like I just said, like what standard should even apply to Sandmann in this case if it were to go like really who is a public figure? And the fact that you are thrown into being a public figure like this kid was, is that even your fault then? Like, people who are public figures who want to be there, like, elected officials and, celebrities and that sort of thing, that's different than, just somebody took a video of you and it went viral. Like you have nothing to say about the fact that you just became a public figure. So should that standard really apply to you when you were a private citizen last week? So I don't know, it's just an interesting question to think about. I don't have an answer for it, and then obscenity, like I said before, this is super difficult because it's really based on individual preference. So a case called Miller versus California, which was decided in 1973, defined obscenity as the average person applying contemporary standards of that community would find that the work is prurient. And prurient means that it is excessively interested in sex. So if a average person, so not like a super liberal person, not a super conservative person, but like your middle ground person would say right now in the city of Marysville that that's obscene, then it's obscene. Or that it's not, then it's not. Okay. So that is kind of like the standard for applying obscenity. And then there's others that are like very obvious. So something that depicts or describes in a patently offensive way sexual conduct specifically defined by law. This is why, and like I always hate talking about this, but this is why like child pornography is always obscene. Because first of all, gross and awful, but second of all, defined by law. So like some people would say like pornography is obscene, but others are like, no, it's fine. But child pornography for sure is because there are laws against it. So, most people are just, well, gosh, hopefully 99.9. I wish 100, but like it's not. But like 99% of people are, patently offended by child pornography. But even the very few who are not, it would still be obscene because it's illegal. And then anything that depicts sexual things but doesn't have any literary, artistic, political, or scientific value to it. So like you can't, like if there's a painting of like a naked woman and people are like, that's obscene. Like, no, it's art, So again, like people's standards are different, but the standard applied in Marysville would probably be very different than the standard applied in like, New York City. So again, contemporary standards of that community. But this idea of obscenity and Miller versus California in general has provided the basis for what's called zoning laws, which means like you can't have, you can't have a liquor store within like 100 feet or yards or something of a church. Okay, so those are zoning laws. You're zoned residential or you're zoned commercial. That's why I don't have like a McDonald's next door to my house, because this is my area is zoned for residential, but it's zoning laws in general. But so the definition of obscenity is defined in Miller versus California has made it so that a lot of restrictions on adult entertainment establishments can be made based on zoning laws and still, remain within the constitutionality of it. And then lastly is fighting words. So fighting words incite hatred or violence from their target. So like if I were to go up and yell at somebody and then they punched me because of what I said, it was my fault. And my speech is not protected. There's a couple of cases, neither which you really have to know, but it just makes me laugh a little bit because there's a city marshal, and this guy named Chaplinsky. So this is Chaplinsky versus New Hampshire in 1942. But like that's why this makes me laugh, because like it's 1942, so like the words that are said are funny. But so Chaplinsky called the city marshal a quote goddamn racketeer and a damn fascist in a public place, and so basically trying to like cause him to punch him or to do other things and become violent in some way. And this case was decided by saying that there was no government protection of speech if the words, quote, by their mere utterance inflict injury or tend to incite an immediate breach of the peace. So again, this is, even though like, I think if you call somebody a damn fascist right now, I don't think people would say that those are still fighting words, but this could set an interesting precedent for, hate speech and where we go from there. So interesting to watch. All right. That is it. We'll cover the rest of the First Amendment. There's my dog. She says we're done. All right. See you next time.